Hello, my name is Yoni Levoritz and I'm from the Levoritz Law Firm. We have offices located in downtown New York City as well as in Nassau County for our Suffolk and Nassau cases. I'd like to talk to you today about religious marriages. Many people think that just because they had a religious marriage means that they don't have the ability to get divorced. Therefore, they go to family court or other places and they don't seek the relief that they have the ability to, such as equitable distribution, which is the division of assets, or maintenance, which is like alimony or spousal support. And they don't seek those things because they believe that they are not married. So I'd like to talk about what it means to have a religious marriage. A religious marriage is one that's officiated by a member of the clergy, whether it be a rabbi, imam, Hindu priest, etc. These are all issues which have to be fleshed out by the court, but for the most part, if you have a marriage contract and you have a ceremony, and you have, of course, witnesses and invitations, and the more you have, the more it equals out to being a marriage. Because even if you don't hold yourself out as being married, let's say your tax returns are not joint tax returns. Well, would it be helpful to have joint tax returns? Sure, because then you're holding yourself out to the government as being married. But if you have single tax returns, again, it depends upon the analysis of the court, but I would say from the case law that I have read, that the bottom line is you're still married. You're still have a legitimate marriage with the expectation of an economic partnership, and you're looking to build on that economic partnership, and therefore you should have a right to share in that partnership. There is a quote which I like on this particular subject that comes from a 1990s case from Queens Supreme Court, which is a lower court case. It's not binding, but I like it. And it happens to be that if it walks like a duck and it quacks like a duck, it is a duck. And the statement was made by the judge when addressing a Hindu marriage that was made by a Hindu priest, or officiated over by a Hindu priest, I should say. And the judge found there to be a lawful marriage, even though there was no certificate of marriage, even though there was no marriage license, even though there was nothing to corroborate it from a legal standpoint. The mere act of getting married in a religious marriage was sufficient for the court to find that there was a religious marriage, and there was therefore a civil marriage to be dissolved. Only the state can dissolve a marriage, and therefore if you have a marriage, you have the ability to seek this relief even if you went ahead and obtained child support from family court, or if you went ahead and received other relief from family court in terms of orders of protection or things like that. You can still go to the Supreme Court and seek a divorce, or at least try to seek a divorce, based upon the fact that you had a religious marriage, and therefore seek part of marital residences, part of businesses, part of any asset that existed, IRAs, 401ks, pension plans. You made a contribution to the marriage by taking care of children. You made a contribution to the marriage by getting up every morning and going to work. These are all factors that the court's going to look at when it comes to contribution and how marital assets should be split. But you shouldn't just give up and not fight for having the marriage enforced and having the marriage going ahead and proceeding with a civil divorce. There is a very good chance you are married, even though you may believe you are not. I want to thank you very much for spending your time with me today, and please remember that these videos are made for educational purposes only and not to form an attorney-client relationship. And I wish you the best of luck. Thank you. Take care.